Thank you.
Sounds good. Thank you so much, Amber. So good afternoon. My name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority, and I appreciate you giving me some time today to talk about the Connecticut Paid Leave and how it applies to workers. We're going to focus on both the Connecticut Paid Leave as well as FMLA. And I'll define those terms. I think it's important for people to understand that these are separate laws, but they're related, and it's helpful to understand kind of where they overlap and where they're separate. We'll try and leave plenty of time for questions. So as Amber said, please put those questions into the Q&A function and we'll address them as we go. So the Connecticut Paid Leave Authority is a quasi-public agency. So we're a state entity that was created to create the paid leave program. We're a brand new program, and it's intended to provide financial relief to Connecticut families, so you don't have to make the choice of caring for yourself or your loved one, or going out to earn, money to make sure that you still have a roof over your head. We want to make sure that people who have to take time off from work because of their own serious health condition or to care for a loved one will still have access to income replacement benefits during that time. We also think it's important to make sure that everybody who participates in this process, employers, administrators, healthcare providers, understand their roles and are able to fulfill their responsibilities. We have a lot of things that we have to do, but first among them is administering claims for paid leave benefits, and our claims went live this morning. But before we get too deep into this, I want to point out that the Connecticut Paid Leave Program is unique in the country because we are entirely employee funded. All of the contributions come from all of the funds for the program come from employees. They deduct 1/2 of 1% from the wages, and that is the employee contribution to the program. The employer who handles the payroll is obviously the one handling the deduction, and they remit that 1/2 of 1% to the Paid Leave Authority, which money goes straight into the Paid Leave Trust. It's not considered a state asset. It's not state funds. It can't be used for any purpose other than to run the program and fund the benefits. Now, these contributions are post-tax, and they're based off of your FICA wages. So when your employer calculates your wages for purposes of FICA, they'll use that same number to determine your 0.5%. And the contributions are capped at the Social Security contribution limit. You should be familiar with this contribution process because your employers were supposed to start taking those contributions as of January 1st of 2021. So you should have seen a teeny tiny reduction in your paycheck over the past year, and they remit those contributions to us on a quarterly basis. Now, as I mentioned, we went live this morning with accepting applications for paid leave benefits. Now, we're accepting applications sort of a month early to smooth out that initial application process, and particularly make sure that people who are going to be out of work in January are going to get their paperwork in before they're actually out of work. And we'll start paying benefits in January for any absences for a qualifying reason that occur on or after January 1st. So let's just define our terms. We're going to be talking today about FMLA and CTPL. FMLA stands for Family and Medical Leave Act. And even though we reference FMLA as a single thing, actually there are two separate laws. There's a federal FMLA and a Connecticut FMLA. Both have been around since the 90s, but the Connecticut FMLA is going to be changing very significantly starting in January. So for purposes of today, I'm going to be talking about Connecticut FMLA as it will take effect as of January 1st. The purpose of both federal FMLA and Connecticut FMLA is to provide eligible employees with the ability to take job-protected time off from work for certain qualifying reasons. Now, leave under FMLA is unpaid. That's written straight into both statutes. But they both say that employers may adopt policies that provide for income replacement during leave, but they don't have to. So there's no law that says an employee has to receive any money while they're out under FMLA. Some of you may work for employers that just provide unlimited PTO, or essentially they just keep you on your regular salary while you're out, which is lovely, very generous. Lots of us work for employers that have policies that require or permit the employees to use their earned accruals while they're out, so you have some source of income. So if you're out for your own serious health condition, you may be required or allowed to use your earned accruals or vacation. So that's the thing to remember about FMLA, is that it's job protected leave, but not necessarily any money, and there's no legal right to money. Until now, with Connecticut Paid Leave. The Connecticut Paid Leave Act is a separate statute. It's a Connecticut law that was intended to create a source of income replacement benefits for employees who can't work for qualifying reasons. Now, Connecticut Paid Leave does not provide any job protection. It's not an additional source of time off from work. It's just money while you're out. You may hear people refer to the law or the program as PFML or PFML. We're not a big fan of that. We actually prefer to say CTPL because we think it's less confusing and less likely to be confused if we use a completely separate acronym from FMLA. So the thing to remember about CTPL is that we provide income replacement benefits. So for FMLA and CTPL, you have to be out for a qualifying reason. And the qualifying reasons are essentially the same, well, there are certain differences between the federal FMLA and the Connecticut laws that I'll describe. The first and most frequent reason people take leave and will be able to receive benefits is for their own medical leave, for their own serious health condition. So if they need time off because they're sick or they're injured or they need to receive treatment, that counts as medical leave. Now, the definition of serious health condition also includes being an organ or bone marrow donor, as well as pregnancy. It's all sort of bundled into medical leave. There's also bonding leave, which is the leave that a person takes if they want to take time for that, to build that emotional and physical attachment with a parent and between the parent and the child. And bonding leave applies to both mothers and fathers. There's no restriction there. And it applies for both children who are born to the family as well as children who are adopted or placed with the family through foster care. There's also caregiver leave. Now, caregiver leave is when the employee takes time away from work to provide care or comfort to their family member who has a serious health condition. It might be taking the family member to doctor's appointments, it might be helping them with physical therapy, or it might just be being there, providing that psychological care and comfort to someone who's sick or injured. There's a special kind of caregiver leave called military caregiver leave. Now, this applies to workers who have a parent, spouse, child, or next of kin who is injured in the line of duty, on active duty in the armed forces. It's a broader group of people that you could take military caregiver leave for because of the next of kin. And there's actually more time associated with military caregiver leave, which I'll talk about. But you have to get documentation from the military that this was an injury or illness that occurred in the line of duty. There's another type of military family leave that's called qualifying exigency leave. Now, this is leave for an employee whose parent, spouse, or child is either deployed or has received a call or a notice order to deployment in the armed services. And they can take this qualifying exigency leave to take time off from work to attend to certain specific activities related to that deployment. It could be going to a sending off ceremony. It could be making an appointment and meeting with the bank or the lawyer to make sure your financial and legal arrangements are squared away. It could be joining your parent, spouse, or child when they're on R&R. So that's a list of qualifying exigency reasons that a person could take qualifying exigency leave. And if they are, they could receive benefits through CTPL. Now, there's a separate Connecticut statute called the Family Violence Leave Act. Now, this is separate from FMLA, both federal and state, but it's a Connecticut law which says that an individual who is directly impacted, so a victim of family violence, can take up to 12 days in a calendar year of unpaid leave to seek medical or psychological care or counseling, to obtain services from a victim services organization, or to relocate if they need to do so because of the family violence, or go to court if they need to because of the family violence situation. So even though it's not technically FMLA, it's job protected leave, and an employee can receive income replacement benefits from CTPL if they're taking time for one of those reasons under that Family Violence Leave Act. So apart from the Family Violence Leave Act, which is a Connecticut law that doesn't have a parallel under the federal law, the other real difference between the federal FMLA and Connecticut FMLA, as well as Connecticut Paid Leave, is the definition of family member. When we talk about that caregiver leave, that you can take leave to care for a family member who's got a serious health condition, federal FMLA says that the family member can only be a parent or spouse, or a child who's under 18, or a child who's 18 and over and has a disability as defined by the ADA, which prevents them from engaging in 3 or more activities of daily living. So federal FMLA caregiver is relatively limited. Under Connecticut FMLA, as it will take effect in January, and under Connecticut Paid Leave, an employee can take leave and receive CTPL benefits if they need time to care for a parent or spouse, or a son or daughter of any age, as well as a sibling, grandparent, or grandchild, or an individual related to the employee by blood or affinity whose close association the employee shows is the equivalent of parent, spouse, child, sibling, grandparent, or grandchild. All right, so a much broader group of people for whom you can take leave. It's important to note that under Connecticut law, we recognize in-laws in all of those definitions. So a parent-in-law, a son-in-law, sister-in-law, all count. That's not true under federal, but Connecticut is broad. And the other broad piece of the Connecticut law is this idea that you can have a family member who's related to you by blood or affinity, who's close enough to you. It's the equivalent of parent, spouse, child, sibling, grandparent, grandchild. What does this related by affinity mean? Well, it's something relatively new to Connecticut. I do admit that, but it's something that the federal government has used for years in connection with sick leave and bereavement leave, and other states and larger municipalities have adopted this as well. Basically, it's a recognition that families come in all shapes and sizes, and your biological family may not be the people who are closest to you. It may be your chosen family who is close to you, or maybe it's a biological family member who really has taken the role of somebody in that sort of first line, that first circle of family relationships. Examples could include, that aunt and uncle who has been very close to you your entire life and who now relies on you to provide that care, who in my family, my great aunt came to every event, every concert, every Christmas dinner, every Sunday dinner. And we did grocery shopping for her because she couldn't drive. And when she was sick, we took care of her. She was the equivalent of my grandmother, and that would now be covered. Or in Connecticut, we don't recognize common law marriages. So if you don't have a marriage license, you're not a spouse as far as Connecticut law has been concerned. But with this new related by affinity, that unmarried significant other with whom you maintain a spouse-like relationship, like Goldie Hawn and Kurt Russell, right? They've been together forever, but they're not married. But now under the new Connecticut definition, Goldie could take care of Kurt, or Kurt could take care of Goldie if one of them was sick. Now, these are very fact-specific situations, so your employer may ask you for a writing so basically you ask you to write paragraph explaining, yes, this person is equivalent to a family member for me. This person is equivalent to a sister, a brother, a grandparent. They can't ask you to notarize it. They certainly can't ask you to provide family pictures or videos or anything of the sort, but they do have the right to have you explain the nature of the relationship. Okay, so those are the qualifying leave reasons, and they apply for both FMLA and CTPL. So I wanted to describe those first. Now I'm going to talk to you about what I think you need to know about Connecticut Paid Leave so that you can utilize this benefit that's now going to be available to you. First question is, do I work for a covered employer, an employer who's covered under Connecticut Paid Leave? Well, the statute says that almost all employers who have one or more people working in Connecticut are covered. This includes nonprofits. This includes employees who work in someone's household, a domestic worker or a personal care attendant. So it's most everybody. It includes the state of Connecticut as to our non-union employees. So managers, appointed officials, legislators, judges, non-union state of Connecticut employees are covered. Who's not a covered employer? Well, the federal government. We can't tell them what to do. Municipalities are not covered unless their unionized employees collectively bargain to participate. Local and regional boards of education, similarly, are not covered unless their unionized employees collectively bargain to participate. Now, but for both towns and boards of education, if the unionized employees collectively bargain to participate, everybody, union and non-union, now become covered. Non-public elementary and secondary schools are also excluded. Railroads, governments of other states, and other sovereign nations, so like the Mashantuckets or the Mohegans, are also excluded. They are not covered employers. So if you work for one of those non-covered employers, you are not participating in the program, you're not contributing, and you wouldn't be able to apply for benefits. There are a couple of exceptions I just want to flag. Employees who don't pay income taxes in Connecticut because of certain specific federal laws don't pay into the Connecticut Paid Leave program either. So this means basically interstate truck drivers who work in Connecticut but live in another state. They don't pay taxes here. Similarly, spouses of active duty military members who've moved to Connecticut because that's where their spouse is deployed, but they've opted to continue paying their taxes in their home state. Well, since they're not paying taxes here, they're not contributing here, they wouldn't participate in our program either. Sole proprietors and self-employed individuals are not required to participate, but they can choose to participate if they want to. They don't earn wages, but they do have self-employment income. So if they enroll, they'll contribute 0.5% of their self-employment income. And if they do enroll, they have to stay in the program for at least 3 years. Okay. So first question, do I work for a covered employer? Second question, if I do work for a covered employer, am I an eligible employee under the Connecticut Paid Leave program? Well, did I earn at least $2,325 in my highest earning quarter, looking back at the first 4 of the 5 most recently completed quarters? So if you're thinking about applying for benefits for January, we would be looking to see, did you earn $2,325 in the highest earning quarter of the last quarter of 2020 and the first 3 quarters of 2021? If you work for multiple employers, we're going to look at your total income and combine all of that to determine if you've earned that $2,325. The other question is, am I currently working for a covered employer in Connecticut? Or if I'm not employed by a covered employer right now, was I employed by a covered employer in the 12 weeks immediately preceding the time that I apply for benefits? Or am I a sole proprietor or self-employed individual who opted into the program? If the answer to those questions is yes, then you're an eligible employee and you can receive benefits. So, okay, you work for a covered employer and you're eligible. What do I get? Well, you get income replacement benefits. Now, those benefits are determined based on your base weekly earnings. Your base weekly earnings are, we look at your highest 2 quarters from the first 4 of the most 5 recently completed quarters and divide that by 26, and that's your base weekly earning. If it's less than or equal to the minimum wage times 40, the benefit payment will be 95%. So it may not be what you're earning right now, it's that average from your highest earning quarters. So minimum wage times 40 is $520 right now. So if you earn less than or equal to $520, you're going to be getting about 95% of that based on that math I just described. If you earn more than $520 a week, when we look at your highest 2 earning quarters divided by 26, your benefit rate will be 95% of 520 plus 60% of the difference between what you earn and 520. However, in all circumstances, the total benefit is capped at 60 times the Connecticut minimum wage. Since the minimum wage right now is $13, the cap right now is $780 a week. Just like the contributions are capped, so too are the benefits. Now, if you're like me, someone describing a math problem is not the easiest and clearest thing in the world. And the good news is that you don't have to try and figure it out just from what I described. You can go to our website at ctpleave.org and look for the benefit estimator. It's on our website, and it's basically in the process section. You can type in what your weekly wage is, and we'll estimate your benefits. Now, this is an estimate because what you're earning right now may not be the same as your highest two earning quarters divided by 26. And you may be getting benefits from your employer that would impact how much benefits you get from paid leave. But it's a good way of just kind of getting a rough estimate so that you can kind of have an understanding of, am I in the 95%? Am I in the 95 plus 60, or am I capped? What else should you know about Connecticut paid leave benefits? Well, as I mentioned, the benefits that you receive may be impacted by whether or not your employer requires or allows you to use the paid leave benefits the employer provides. So if you want to know what you might be getting, you also need to know, does my employer provide me with any paid leave time off or any paid time off? And if so, will they require me to use it or allow it to be my choice? And beyond that, are there any rules? Some employers say if you have your out for your own serious health condition, you must use your sick time, but you don't have to use your vacation unless you want to. Some employers say your sick time's for you, you can't use it for caregiver. So you need to know what the rules are. You also need to know if your employer is offering you a short-term disability policy. And by that, I mean a policy that's from the employer. If you've gone out on your own, and bought something from Colonial Life or Aflac, that's yours. You're paying for it on your own. You're the owner. That doesn't impact this benefit calculation. But if it's a short-term disability policy or long-term disability policy, for that matter, that's provided by your employer, it may impact the benefits. And you need to know, does the policy say it's going to be the payer of last resort and you have to use everything else first? Or is it the first one you go to? And are they paying you 100% or are they paying you something else? Basically, there are 4 scenarios that a person can fall into, depending on whether the employer allows or requires the employee to use that paid time off, as I said. Now, I want to note something. This is one of those changes for Connecticut FMLA. Starting in January, an employer may require an employee to use their paid time off when they're out on Connecticut FMLA, but they can't force you to exhaust all of your PTO. They have to let you hold on to at least 2 weeks, if you want to, for some other purpose. So just keep that in mind. If you have no paid time off, because you've used it all or you don't get any, or the employer lets it be your choice and you don't want to use it, then you'll receive your full amount of CTPL benefit based on the statutory calculation for the full amount of time that you're out on leave. If you have enough PTO to cover your entire leave and your employer requires you to use it, or you choose to use it because you want to get full pay, or you want to save your CTPL for another reason, all that's fine. That's up to you. You get your full income replacement through your PTO. You're not even applying to us for benefits, or you apply and we say you've already got your full income. We're not going to tap into that CTPL allotment yet. So it doesn't go away. It's just not accessed right now. More often, you could see a situation where an employee has some amount of PTO, but not enough to cover their full leave. So they'll start getting their full income replacement through that employer-provided PTO. And then maybe that only covers 2 weeks. They'll start getting their CT paid leave benefits, beginning week 3. Then there's another situation where maybe the employer has PTO, but it's not to cover the full amount. Maybe they have a short-term disability policy that only covers 50%. Or maybe the employer says, you go to CTPL, you're going to get a certain portion of your income covered by CTPL, will make up the difference. All of that's allowed. We just need to know what what the employer is doing. So we can ensure that we're complying with a statute that says an employee can receive benefits from paid leave and the employer at the same time, as long as the total amount does not exceed 100% of the employee's wages. So we will be asking you, when you apply to us, to have your employer fill out an employment verification form. And part of that form just gives us the opportunity to find out from the employer, what are the rules? Are they paying? Are we paying? Are they going to top it off? Are they paying first, but only 50%? That way we can make sure the benefit amount is the right amount. The other thing you need to know about what do you get from CTPL is how long do you get these benefits? Well, if you're eligible and it's a qualifying reason, you can receive up to 12 weeks of income replacement benefits in a 12-month period for all of those leave reasons I described, including military caregiver leave, with 2 exceptions. First, family violence leave is only 12 days in a calendar year. And our job is to reimburse you for when you're out on unpaid leave. So if you're out for family violence leave, we're going to reimburse you for those 12 days, but that's it. And there's also a provision that says if an employee has a serious health condition resulting in incapacitation during pregnancy, they can receive up to 2 additional weeks of CTPL benefits. So if you're pregnant and you are out on bed rest, you could access those extra 2 weeks. But serious health condition resulting in incapacitation includes treatment. So maybe it's you have to go to prenatal visits and you can't schedule those around your work schedule. So you're taking unpaid time off to go to those prenatal visits. You could get benefits for that. Or maybe you have an unrelated serious health condition. Maybe you break your leg while you're pregnant. You could receive those extra 2 weeks in addition to the 12, just for that period of time. Okay, that's all great. I've told you all the things you can get. How do you access them? Well, let's talk about how you apply for paid benefits. You can apply today. We're open today. If you go to our website, ctpaidleave.org, and click on the process button, you'll see this picture. We give you a step-by-step instructions, including videos, on how to submit a claim. If you do it online, that is the fastest and frankly easiest way. But we will accept applications through mail, email, fax, or telephone. It just may require a little bit more time because it's really a step-by-step process, and doing it online enables us to kind of guide you through that process. There is a statute that says that if you apply to Connecticut Paid Leave for benefits, you do have to notify your employer. They can't approve or deny the benefits, but they do have a right to have notice that you're applying. So I just wanted to remind you about that. When you submit the claim, it will be processed by our claims administrator. We've entered into a contract with Aflac Insurance, and they're going to be administering our claims. So as I mentioned, you can do it through ctpaidleave.org, or you could call Aflac directly and talk to our claims reps. They will walk you through the checklist, ask you the reason for leave, because that governs the documentation you need to provide. They're going to ask how long you're going to be out, and if it's going to be a single leave for a period of time, if you're going to be working, but working fewer hours, or if you're going to be out on intermittent leave, which is separate leaves, all for the same reason. They're going to make sure we know what your jobs are and sources of income. Aflac will determine your eligibility using the standard I described, and make sure you work for a covered employer. And they'll review the documentation you provide to approve or deny your claim. If they deny it, they'll explain why, and you have an opportunity to request reconsideration. If it's approved, they'll calculate the benefits using that process that I described, and they'll issue the benefit payments to you. Now, the benefits will be paid through electronic transfer to your bank account or through a stored value card, which is basically a debit card that we will fund. We'll be paying the benefits on Tuesdays. If it sort of that's the regular routine. If you get approved at the beginning and it's not a Tuesday, you'll get your benefit. But thereafter, it'll be every week on a Tuesday. And basically, we're paying them. It says 2 weeks in arrears. Really, it's 10 days. So if you're out for that first week of January, from January 2nd through the 8th, The benefits will be issued to you on the 18th. This makes sure that we have time to ensure that we've calculated it properly, we've taken into consideration any offsets, so that the money when you get it is correct. Now, you'll be responsible for letting us know if there are any changes to your leave. Are you going to be out longer than you expected? Are you going back to work, but on a reduced schedule? And if you're out for intermittent leave, you may not always know what days you're going to be out. So we're going to be asking you to just give us those days as they occur. And you'll do that through the portal. All right, that's basically what you need to know about Connecticut Paid Leave in a nutshell. Let me make sure you have the information you need to know about FMLA. Now, as I mentioned, FMLA is Family Medical Leave Act. There's the federal FMLA and Connecticut FMLA. First thing you need to know is, do you work for a covered employer? To receive federal FMLA leave, you have to work for an employer who has at least 50 or more employees within a 75-mile radius, or you work for a governmental entity of any size. Now, the federal government, state agencies, towns, schools, they're all covered under federal FMLA. Under Connecticut FMLA, it's very similar to Connecticut CTPL Paid Leave. Almost all employers who have one or more people working in Connecticut are covered under Connecticut FMLA, including the state of Connecticut, as to all of our state employees, union and non. But certain entities are not covered under Connecticut FMLA, like, oops, sorry, this was an error. The federal government is not covered. Municipalities and local or regional boards of education are not covered, and there's no collective bargaining to be included. I need to fix that before we send this to you. Non-public elementary and secondary schools are also not covered under Connecticut FMLA, as are in governments of other states, railroads, and other sovereign nations. They can all adopt policies that are similar to Connecticut FMLA, but they're not truly Connecticut FMLA, and they won't be enforced by the Department of Labor. So, do I work for a covered employer? Am I eligible? Well, for federal FMLA, you have to show that you are employed by your employer for at least 12 months. And it could be cumulative. So you could work for them for 3 months, go back to school, and then get a full-time job, and that 3 months would count. And you have to show that you worked for them for at least 1,250 hours in the 12 months immediately preceding the leave. So part-time workers, seasonals, they may have trouble qualifying under federal FMLA. Under Connecticut FMLA, as of January 1st, the only thing you have to show is that you worked for the covered employer for at least 3 months in the 3 months immediately preceding the leave. There's no hours worked requirement. And what do you get under FMLA? Well, you get job protected leave. Federal FMLA is 12 weeks, and that's in a 12-month period, with the exception of military caregiver leave, which is 26 weeks in a 12-month period. I apologize for my dog. There's someone walking down the street. Connecticut FMLA, as of January 1st, is a 12 weeks in a 12-month period entitlement for all those leave reasons, except there's that 26 weeks of leave for military caregiver and that 2 weeks of extra leave for the serious health condition resulting in incapacitation during pregnancy. Finally, Family Violence Leave Act, as I mentioned, is a separate law that provides up to 12 days of leave for those specific reasons in a calendar year. How do you apply for FMLA leave? Well, that's something you do with your employer. You have to notify your employer that you need the time off from work for a qualifying reason. You don't have to say FMLA, but it's probably a good idea to just mention FMLA, just so that you know, that they know, that you know that this is FMLA. If you know that you're going to be out, you should tell them 30 days in advance. But if you don't know that you're going to be out, the need for leave is not foreseeable, you have to let them know as soon as practicable. The employer has 5 business days to tell you if you're eligible under Connecticut FMLA or federal or any other law, and to provide you with something called a notice of eligibility and rights and responsibilities. This is not leave approval. This is just, yep, you're eligible, and this is the information we need to review your claim. It's a med cert, it's a caregiver form, it's a family relationship form, it's a military orders. They have to tell you what information they need. And you have 15 calendar days to provide that documentation to your employer. If you're having trouble getting them, maybe the doctor's not responding to your calls or can't get the orders for the qualifying exigency, tell your employer that you're having trouble. If you tell them, they do have to give you a reasonable amount of additional time for you to get the documents in. If you don't tell them and you just don't provide the documents, they're going to deny your leave. So talk to them. Once you give them the forms, they have 5 business days to review the forms. They'll let you know if they're missing anything and give you time to cure it. They have at least 7 days. And then they'll either approve it or tell you you're not approved. It's not a covered reason. If they're approving the leave, they have to tell you if you have to use your accruals or not, if you have to report in, if you are out on your own serious health condition. They can tell you that they need you to do a fitness for duty before you come back, and but they have to let you know that that's going to be required. And then you actually have to let them know when you're out, right? If you have a foreseeable leave, maybe all this has happened before you've even gone out. So now you woke up and you're in labor, and you didn't think you were going to be in labor today, but baby's coming. You have to call in and say, okay, I'm in labor. I'm going out on my FMLA leave now. Or maybe it's an intermittent leave. So you know that you're going to be out for this leave reason, but today's the day I have the flare up of my Crohn's disease. I can't come to work. Don't just call in sick. Call in and say, I need to take my approved FMLA. Your employer is going to track the time to make sure you're not exceeding the 12 weeks that you're entitled to, so that you know how much time you've got and they know. And then the whole kit and caboodle here is job protection. They have to return you to the job you had before you had leave. And they can't discriminate against you or retaliate against you because you're taking leave. They can't ding you on your performance evaluation because you're taking intermittent FMLA. They can't say you're not reliable because you have caregiver responsibilities. A couple of things to remember. This is really under the Americans with Disability Act and the Connecticut Employment Practices Act, but it's important to know that if you're out for your own serious health condition, which qualifies as a disability under those statutes, and you come back and you say, okay, I can come back to work, but I might need some modifications. I have a lifting restriction for the next 3 weeks. They have to work with you on that. They can't say, oh, no, you have to be 100%. So just be aware that you have that entitlement. Remember, even when you're out on Connecticut FMLA or federal FMLA, you still have to follow your employer's policies, particularly relating to attendance and call-in. Don't ghost them. And when you're taking FMLA, you don't get into the specific reasons with your supervisors. You don't have to share your medical information or your family's personal business, but you do have to say, hey, I've got that approved FMLA. I'm taking it tomorrow. You are responsible for providing your employer and us, by the way, with those med certs and other required documents. The med cert is just going to be about that specific leave reason. We're not going to ask about other conditions or your whole history, but we have the right to know, is this a serious health condition? Be aware of other laws, like federal FMLA, the ADA, the Pregnancy Discrimination Act, that may apply to your situation. If you're curious, you might want to check out the Equal Employment Opportunities Commission at www.eeoc.gov, which lists all the sort of job protections that employees get. Or you can go to the CHRO website on the Connecticut Human Rights and Opportunities website on ct.gov/CHRO. And finally, I just want you to know that the federal FMLA and Connecticut FMLA are very clear that in all circumstances, it's the employer's right and responsibility to designate time off that qualifies under FMLA as FMLA. So you can't say, oh, I don't want this to be FMLA. I want to save my time. It protects you to have it be designated as FMLA because then you have that job protection and you know that they're counting it against you. You're not surprised later. And it protects the employer because they want to protect themselves from an interference claim. So don't be surprised when they say, hey, this seems like an FMLA situation. We need to process it that way. All right, I see that maybe some questions. I want to make sure I have time for that. But if we don't have time for all your questions today, or if after this session ends, you think of some questions, you still have options. You can contact us at the Connecticut Paid Leave Authority, www.ctpaidleave.org. There's tons of information on our website. We've got frequently asked questions. We've got videos. We just deployed a whole new page last night of information about how to apply. So there's lots of information. If you can't find what you're looking for, you can use our Contact Us button on the website and submit your question to us in an email. And you can tell us you want a phone call back or an email back, and we'll respond to you. If your questions are more specifically about FMLA and not paid leave, you can go straight to the Connecticut Department of Labor. They're building a new enhanced FMLA page, but you can go to ct.gov/DOL and look on their page for information about FMLA. You can also go to www.dol.gov/FMLA and get information about federal FMLA. If you apply for a claim and you have questions about your specific claim, you will be able to get information about your specific claim through the CT Paid Leave portal account that you create when you apply, or by contacting AFLAC directly. But that's for your own specific claim. That's because that's confidential information. Only limited people have that information. All right, I'm going to start sharing my screen and see what kinds of questions have come in. Let's see. Question came in about eligibility under Connecticut Paid Leave, where it says employed for at least 3 months by the employer. Is it the employer or any employer? For Connecticut Paid Leave, we look at your earnings from any of your covered employers. But for Connecticut FMLA, you have to work for a specific employer for at least the 3 months before you go out on leave to get job protection from that particular employer. Okay, so there is a need to work for that employer for at least 3 months in order to get job protection from that specific employer. No question, does the family violence leave reduce the CT paid leave allowance, or is it in addition? So the Family Violence Leave Act, those 12 days in the calendar year are in addition to your FMLA job protected leave entitlement. But the 12 weeks of income replacement benefits that you get under CT paid leave includes the 12 days. So it's 3 months, so it's 12 weeks plus 12 days for Connecticut job protected time off from work. But the total amount of income replacement you can get is 12 weeks, and that includes your family violence. Okay, so to confirm, will AFLAC send the employer a notice to confirm our internal policies regarding paid time off and short-term disability? I'm so glad you asked that question, because no. What's going to happen is the employee who applies to the authority through AFLAC for benefits will be provided with an employment verification form for you to give to your employer, because the employee is going to know best, certainly better than we do, who at the job to give, who can fill out that employment verification form. That employment verification form asks for verification of the employee's work schedule and asks if the employee will be receiving any income replacement from the employer. And if so, is the employer going to be primary or secondary? Are they the payer, the first payer, or the secondary payer? If they're the secondary payer, that's all we need. If the employer is the primary payer, we need to know, what percentage of the income they're going to be replacing. So that's the specific information that the employer will fill out in the employment verification form, and the employer will send that to AFLAC. Then, if the employee is approved for income replacement benefits, we'll notify the employee and the employer that Johnny Jones has been approved for CTPL benefits from the period of January 5th through February 26th at average benefit amount of X. We're not going to tell the employer anything about the specific reason for leave or any of the medicals supporting it, but we will let them know that it's been approved with some basic information. New question came in, is intermittent leave allowed under Connecticut FMLA? Yes, it is. So intermittent leave is when you have one reason where you may be out of work for several different days, either scheduled or unscheduled. They may be because you have a flare-up, as I said, of your Crohn's disease, or maybe you have to take your family member to doctor's appointments. So that's intermittent leave, and that is allowed under federal FMLA and Connecticut FMLA, and the Connecticut Paid Leave Act will approve benefits for someone who is out on unpaid intermittent leave. Okay. If the employer's amount is less than the paid leave, does the employee choose? So I think this is a question going back to this whole intersection of employer PTO and paid leave. And as you mentioned, we need to know what the employer's policy is. My house was incredibly quiet until I started this webinar. We just apologize for the noise. If the employer requires the employee to use their PTO, then that's the employer's ability to make that decision. If the employer allows the employee to choose whether or not to use the PTO, then it is the employee's choice. And as I said, if the employer provided PTO is less than the full wages, the employee can receive both benefits from the employer as well as benefits from the paid leave authority, as long as the total amount does not exceed 100%. Is there a minimum amount of time that an employee can take intermittent leave? Great question. Under both federal FMLA and Connecticut FMLA, the rule is that the employer can establish the amount of time that they'll consider for intermittent leave. And basically, they would let the employer decide because they knew that different employers have different payroll systems. So they wanted to make it something that an employer could track. However, but the employer cannot require an employee to use more than an hour. So say the employee says, our minimum increment is 1 hour. If the employee is out for 15 minutes or 45 minutes, we're still going to reduce their federal or state entitlement bank by an hour. They're allowed to do that, but they have to tell you they're doing that. If they say we do it by 15 minutes, then whether you're out for 5 minutes or 15 minutes, the amount of time that's reduced from your total of 12-week entitlement will be 15 minutes. But they can't make it be more than an hour. And you can't make somebody, you can't say, I'm counting you as being absent for 4 hours when you were only absent for an hour. Okay, so that minimum increment is whatever the employer sets, as long as it's less than an hour. So I hope that's clear. For paid leave, we're going to pay basically to the minute of what you tell us your absence is. So if you tell us that you were out for 47 minutes, then we'll pay you, and you didn't get paid for those 47 minutes, we'll pay you for that. If your employer requires you to sort of be out for an hour as the minimum increment, and therefore you lost an hour's worth of pay, then we'll reimburse you for that. It looks like I've answered all the questions in the Q&A. Amber, is there anything that, see, nope, she's saying there's nothing else coming in. I'll kind of tap dance here for a minute to see if anyone wants to type in any more questions. But while I'm waiting, I will remind you again to check out ctpleave.org. Make us a favorite. If you anticipate being out on leave in January, I encourage you to apply for or start your application now. You can go to ctpleave.org and start the process. And if you're not sure, check us out because we'll show you information, like the information you need to so you can kind of have it all ready to go. There is a identification verification for accessing the website. It takes about 10 minutes, but it's something you need to kind of plan for. And we do also need to validate your identity for purposes of Connecticut Paid Leave. So in addition to providing us documentation about your leave reason, we will ask you to provide identity verification information so that we can make sure that you're you and not some, Russian mafia person who's trying to, commit fraud. So our website tells you all of that information and explains sort of the different reasons, the documentation you need for all those different reasons, and kind of gives you kind of the step-by-step process. All right, no other questions have come in. So I appreciate your time and attention this morning. Great questions. We will send you the slide deck fixed with that one error that I noticed. So I'll fix it before we send it out. And we will share the link to this recording. And I hope that you all have a lovely afternoon. Thank you again for your time today.